a big hello from me as well to everyone. Welcome to this Summer of Law webinar by the University of Kent. As I said, the aim of these webinars is to offer a taste of what the legal topics you can study in a law degree at university, and also to give you an insight into the distinctive critical approach to teaching law in Kent Law School. In the previous Summer of Law webinar, if you attended, or if you didn't, you can watch it on YouTube. My colleague Sheena York talked about asylum and the law and whether Britain really welcomes refugees. She also talked about the legal, social, political implications of the new UK legislation, the Nationality and Borders Act, and what this means for the UK's treatment of refugees. We are very pleased that you are able to join us today for this session on protest and the law. I am Mohammad Nayyeri. I am a lecturer in law in Kent Law School. I teach on a number of modules, including public law, law of the European Union, critical introduction to law, and so on. So I have years of experience of working in the field of human rights as well. I have conducted of cases, representations at national and international level. And I'm delighted to be joined in this webinar by my colleague, Sean Lewis. Sean, would you like to introduce yourself?
Yes, thank you, Mohammed. So I am also a human rights lawyer and have also worked for many years in the field representing clients and undertaking research for human rights organizations. And currently, along with Mohammed, I teach at the University of Kent. I teach international human rights law, or I have taught international human rights law. I also teach English law and human rights and international migration law, mainly from a human rights perspective. We're both very concerned, as you can see, with the rights of human beings. Yeah, so it's my great pleasure as well to welcome you to this session.
Thanks so much, Sean. Before we start, perhaps I should make a quick reminder to everyone that we want the webinar to be interactive, and we welcome your inputs as we are going to raise some questions and as we go through the topics. So please use the chat function to share your views and take part in the questions. But keeping in mind that when you comment in the chat, you can choose who can see your response. So if you address it to everyone, other participants will be able to see your answer. But if you address it to host and panelists, only we can see them. Okay, let me get the slides up. Okay, do you see the slides? Okay, good. Okay, so our focus today is on the right to protest. We are going to discuss what it means and to what extent it is protected by law. But before we do that, let's do a warm-up exercise. So I'm going to put some pictures on the screen from some protests in the UK in the last few years. And what I would like you to do is to try and see if you can recognize any of these events and the reason these people are protesting. Well, I recognize not everyone is from the UK. We have international students as well. So don't worry if you don't recognize them. But let's try and see how many of these you may have seen in the news, for example. So if you know, for example, where this is or what the protest is about, please use the chat function and type your answers in the chat. So there you go.
No answers at the moment.
Okay, that's okay.
We've got one answer.
Okay.
A couple of people have said, is it the Sarah Everard murder?
That is great knowledge. Yes. And there are clues in the placards, and also you can recognize it, and you can see some of these also took place during the lockdown, for example. So that's great.
Someone says in the bottom right, is that a protest about COVID?
Yes, good. This is some people who don't think COVID is real. They are protesting against it, and they deny it, basically. Let me show you.
They're protesting against the obligation to be locked down, perhaps. I can't actually see that this particular one, or against vaccination. Against
wearing mask or vaccination, right? So this is the first set. Let's do some more.
Sorry, Mohammed, someone is also saying, is one of the others the Police Crime Sentencing and Courts Act when it was a bill?
Oh, fantastic. That's absolutely what it is, what it was. I'll come back to that.
Okay, so we've got several people saying Black Lives Matter, Extinction Rebellion, and Bristol Black Lives Matter. So this is brilliant.
That is fantastic. I didn't expect for participants to know all of them, maybe some of them, but not all of them. We have now all of them.
One of them said top left, removing statues of slave traders in Bristol, and right, Black Lives Matter.
Very specific knowledge, yeah.
One of them is the Coulston Four. Yeah, this is excellent.
Excellent. Okay, so there you go. So these are the type of things, and this is exactly, as you said, the protest against the policing bill, which has now become an act of parliament, is Policing Act now. And it contains some provisions relating to the right to protest. We are going to talk about it in more detail in this webinar. So well done, those of you who spotted these. And so these are the examples we are going to consider in terms of, do they have the right to protest? And what is the right to protest? So very briefly, let me show you the structure of this webinar. And this is an outline of for the rest of this session, as we are going to first explain the right to protest and deal with some skepticism about it. We will then see some examples from around the world where the right to protest is suppressed. We will then discuss some challenges to the right to protest in the UK, including the new laws and proposals by the government and their implications for our ability to protest, and more broadly on our human rights. So over to you, Sian, to get us started by explaining what the right to protest is.
Wonderful, thanks, Mohammed. So we're now going to, as Mohammed says, look at what is the right to protest. As we go, there'll be some slides which give you some extracts from various either documents or cases. So if we ask the question, what is the right to protest? I think the answer to that needs to be, it is a combination between the right to freedom of expression and the right to freedom of assembly. Expression being able to speak or write, or to communicate in other ways, a view or a purported truth. And the right to assemble is the right to get together in order to do various things. You might assemble in a club for the purposes of sport, but you might also assemble for the purposes of voicing an opinion. And you might do that in the street, you might do it in a park, you might do it in the privacy of your own home. But as I say, the right to protest combines these two notions, the right to freedom of expression and the right to freedom of assembly. And they are both rights at the heart of a liberal democracy. Without them, we can't voice our opinions very effectively. And we can see it articulated very clearly in this case of Hubbard against Pitt, a Court of Appeal case in which the then Lord Denning said this: the right to demonstrate and the right to protest on matters of public concern are matters which it is in the public interest that individuals should possess. So it's not just about us as individuals having those rights, although that is a very important part, but it is also in the interest of the public at large that individuals should possess the right to protest. And he carries on to say, indeed, they should exercise without impediment so long as no wrongful act is done. It is, he goes on to say, often the only means by which grievances can be brought to the knowledge of those in authority, at any rate with such an impact as to gain a remedy. And we've seen how very often issues of very strong public interest are brought to the attention of those in authority through loud, noisy protests. Lord Denning continued in the same case, the courts should not interfere with the right to demonstrate and to protest any more than they interfere with the right to free speech, provided that everything is done peaceably and in good order. If we can go to the next slide. Here we've got the right to freedom of expression, one of the two rights that are kind of that underpin the right to protest, and that's the right to freedom of expression under the European Convention on Human Rights. The European Convention on Human Rights is part of, at the moment, English domestic law by virtue of the Human Rights Act, which brings it into our law. And it says this: everyone has the right to freedom of expression. This right shall include freedom to hold opinions. So that's, you can hold any opinion you like, but also to receive information and to impart information and ideas without interference by public authority and regardless of frontiers. There's another sentence there about the licensing of television that we don't really need to think about just at the moment. If we can move to the next one. The European Court of Human Rights, which is the ultimate arbiter of the European Convention on Human Rights, in other words, it determines the scope of the rights in that treaty, has said that in its case law that the right to freedom of expression is a cornerstone of a democratic society. It covers all kinds of expression. So it isn't just the written word, it can be artistic expression, for example. But very importantly, it includes expression that is not only welcome and openly encouraged, but also expression that shocks, offends, and disturbs. And I think that's really important for us to remember. It also provides wide protection for political speech, so wider than sort of other types of speech that relates to institutions of government, policies, politicians, and this applies at local, national, or international levels. And it provides a very high degree of protection for public interest speech, anything that is in the public interest that we should know about. Now, the court has held with respect to speech attacking governments that the limits of permissible criticism are wider with regard to the government than in relation to a private citizen. And that seems to be fairly obvious because obviously the government's ability to impact our lives is in large part much bigger than private citizens. And even it's wider than just in relation to a politician of a general kind, because the court said the dominant position which the government occupies makes it necessary for it, that is the government, to display restraint, particularly where other means are available for replying to what may be unjustified attacks and criticisms of its adversaries or the media. And that was a case of Castells against Spain. Now, if we go to the next one, we'll see that this second right, which sort of underpins or comes together with the first right, is the right to freedom of peaceful assembly, and that is protected in Article 11.1 of the European Convention on Human Rights, which is as well as part of our domestic law. And that says everyone has the right to freedom of peaceful assembly. Now, I think it's really important that we remember this word peaceful, because that's going to come up again in a minute. And to freedom of association with others, including the right to form and to join trade unions for the protection of his interests. This was written in the 1950s, before it was discovered that women were also human beings. So it applies to men and women, is what I'm trying to say. In fact, it applies to all people. The European Court of Human Rights has, can we just pop back? In the case of Navalny, you may have heard of Navalny, against Russia. And that was in 2018. And the European Court of Human Rights said Article 11 only protects the right to peaceful assembly. See, remember I highlighted those words just a moment ago? A notion which does not cover gatherings where the organizers and participants have violent intentions. Those guarantees of Article 11 therefore apply to all gatherings except where the organizers and participants have such intentions, i.e. violent intentions, incite violence or otherwise reject the foundations of a democratic society. And that's referring to I think Article 19 of the Convention, which refers to undermining the democratic nature of society. So the conclusion that we can draw from this case law is that the right to freedom of peaceful assembly, that word peaceful relates to the absence of violence rather than the absence of noise. It has absolutely nothing to do with the noise that a protest makes, and that becomes important in a minute. We go to the next slide. So you may ask, well, can people say anything they want? Can they shout, racially abusive things in a protest? Well, the answer is clearly not. Rights can be limited, but they can only be limited if those limitations are clearly provided for, clearly articulated in the law, and in accordance with the case law of the Convention, are necessary and proportionate and carefully tailored to the requirements of certain things. And you see these listed in Articles 11.2 and Article 10.2. So I referred to Article 10.1 and 11.1 just now. Now we're going to the second paragraph, which states in so many words, or if I kind of summarize it, these rights may not be limited unless, and they need to be necessary in a democratic society, etc. And the bases upon which these rights may be limited are limited to these bullet points. So in the interest of national security, in the interest of territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation of the rights of others, for the prevention of disclosure of information received in confidence, or for maintaining the authority and the impartiality of the judiciary. But one final thing I'll just mention before I hand over back to Mohammad is that in this context where rights may be limited, they may not be limited so far as to extinguish the right altogether, because rights must not be rendered theoretical or illusory. Rights must be practical and effective. And of course, as I indicated earlier, limitations may be imposed where there's violence, where the national security is affected, and in the interests of others, to protect others, for example, from nasty racist protests and so on. Anyway, I'll hand over to Mohammad now, who's going to talk about skepticism about the right to protest.
Yes, the right to protest has its skeptics. Let's have a quick look at their arguments and see if we can counter them. Also, if you also think that there are arguments against the right to protest, feel free to put it in the chat. We'll try to address them if we can, if we have time. the first strand of skepticism is that there's no need for protesting in a democratic context. In democratic countries, the skeptic would say elections do what protests are supposed to do in a non-democratic country in allowing dissenting views to be heard. So it's not necessary, they say. A potential answer to that is that peaceful, non-violent direct action sometimes become necessary, even in a democracy, including when other means of protest that are available to us are exhausted. For example, despite the clear opposition and legitimate arguments and concerns against the government policy, the government may decide to completely ignore that and go ahead with that policy. When there is such a democratic deficit, people are left with very little option but to take peaceful, non-violent protest to have their voice heard.
I've got a comment, Mohammed.
Yeah.
A protest in a democracy shows the failure or flaw of representative democracy, clearly because protests happen due to lack of representation.
Fantastic. That's very much in line of with what we said. You can develop that argument further, and perhaps we can use this quote or this thought by Lord Hailsham, the former Conservative Lord Chancellor, who claimed that where the government controls Parliament rather than Parliament controlling government, what we have is an elected dictatorship. So some people are asking, is this what we have now, where the ruling party has a huge majority of seats in the Parliament and can push almost any legislation through? So this is the sort of thing you will examine when you study constitutional law as part of your law degree. So let's move on to the next line of skepticism, which is that protests do not make any difference. So in 2003, 2 million people marched in the UK against the Iraq war. So do you know if this was successful? You can put a yes or no in the chat. Do you think it was successful in persuading the British government to retreat from its policy?
They're saying no, no, it wasn't. No.
Absolutely right. Even though you are too young to know this probably, but that's absolutely what happened. It did not make a blind bit of difference with Tony Blair's determination to proceed with the war, a war that the UN Secretary General described as illegal. So Tony Blair was re-elected 2 years later. So is there any merit in that argument? It doesn't make any difference. But some people might say it is true that protests sometimes have a startling power, like the poll tax protests in the 1980s, the protest outside the South African embassy in the 80s, which formed part of the picture that brought an end to apartheid. So striking also, which is a form of protest about working condition or threat of strikes, have also sometimes led to jobs being saved or wages being protected. But protests do not always lead to change, right? So it is only about, but we need to remember, it is not only about immediate change. Sometimes even unsuccessful protests have long-term effect. Another line of skepticism,
Can I just interject?
Yep.
Someone has a longer comment here. It may not have made a difference in that the government didn't do anything. However, it does show the countries affected that they have the support of the people, even if the governments are against them. It shows that the government or elected parties do not always share the opinion of the people. I think that's a really important point.
Yeah, very important point. And I think it's something like that, the protests and the campaigns against the war in Iraq led to creation of this, for example, this constitutional convention, that at least parliament should be consulted. It shouldn't be just the government deciding that. So, okay, that's great. Let's move on very quickly to the third skepticism, which says that some protests are about unwelcome or wrong views, or some forms of protests are harmful to others or seriously interrupt our lives. How about that? Should they have the right to protest? I mean, I can give you 2 points on that. So
someone is saying yes, they should have the right to protest.
Good, which is, I agree with that. And I have 2 arguments for that. Firstly, as Sean mentioned, the right to freedom of expression and assembly are not absolute or unconditional rights under international human rights law. They can be legitimately and lawfully limited on some exceptional grounds. And secondly, we may fundamentally disagree with some people and the reason they protest, but this is about the right, and we need to protect it because of its value to our society.
And one of the commentators says fairness goes both ways.
Yeah, absolutely. And John Stuart Mill, the British philosopher in the 19th century, also seems to agree with us. He says that silencing the expression and opinion robs the human race, both now and future generations. So here in this quote, he says it is important for ideas to collide so we can exchange truth for error and get a better handle on the truth. So we can develop our arguments and counter those arguments against the right to protest. So let's move on to...
Sorry, there was one more comment here. There was a question, what about the Salman Rushdie issue?
I mean, we cannot comment on all of the examples, but the general principle is that we may disagree, fundamentally disagree with some people, but that's about their rights. And if that right corresponds to any of those limitations and grounds that Sean mentioned, it can be legitimately limited. But in general, we have the right, and it should be and when it is in the interest of the public and the society, we should protect that right to protest. There are so many important functions for that right, and we shouldn't be trying to suppress voices of people as long as it is peaceful and it's non-violent. It is protected. These are human rights.
And I think it's worth just adding that the European Court of Human Rights, when interpreting the limitations to the rights, interprets those limitations narrowly so as to give the biggest protection that is possible to the right. You know, that goes to that whole question of not extinguishing the right by the limitation.
Yeah, thank you. Okay, let's move on to the next part, which we are going to have a quick look at some current challenges on the right to protest, starting with some relatively recent examples from around the world where protests have been suppressed. If you have any examples of protests in other countries being suppressed, please put them in the chat.
So we've got Russia, Hong Kong, Venezuela. So I'm assuming this is in relation to your question. Are there other places where Afghanistan, where the right to protest is suppressed unduly?
Yeah, I have also some examples for us. This is from Sri Lanka. People have been experiencing a national economic crisis there, and they have been protesting. And the government of Sri Lanka deployed military with shoot-on-sight orders with use of live ammunition. Someone mentioned Hong Kong. That's exactly one of the best examples we have seen in recent years with those mass protests. And China has been trying to tightening its grip on Hong Kong and has cracked down on protests in the city, especially since 2020, when they imposed a national security law that gave China new powers to punish critics and silence dissenters. The other example is Rwanda, and it was in the news that refugees have been shot by Rwandan police when they engage in protest over reduction in their food rations. If you have been following the news or attended the previous Summer of Law webinar, you may notice that it is relevant to some recent developments concerning the UK and Rwanda. If you know the answer, you can type in the chat.
Just before we get to that one, somebody also suggested North Korea as a country where the right to protest is severely repressed.
Well, yes, it doesn't exist there at all.
Not at all.
So
there doesn't seem to be an answer to Rwanda. Oh, yes, there is. Sending immigrants. Oh, someone says Bangladesh, India, and Myanmar. So those are other examples. And yes, sending immigrants is one of the answers.
Yes, absolutely right. The UK government is planning to deport asylum seekers to Rwanda. And the question is it safe to send them to Rwanda in light of this and other human rights abuses? So another example is Iran. And in November 2019, there was the Iranian government announced a sudden increase in the fuel price, and protests erupted across Iran. Iranian authorities used unlawful, lethal force and war-grade live ammunition to suppress the protests. They killed hundreds of protesters and bystanders, including children. They also detained thousands of protesters and subjected many of them to enforced disappearance, torture, and unfair trial. Amnesty International has recorded the names of more than 300 victims, but everyone believes that the number of those victims are much higher than this. Okay, now...
Mohammad, a couple of points here. Someone has mentioned Sudan and Israel as well.
Yeah, I mean, the worldwide picture of the right to protest is very grim. It is not respected and observed in many, many places. And it is suppressed heavily in many countries.
And just a couple more observations about one about the Amnesty report and one about the previous picture. The Amnesty report, I noticed it looks like there are children in there. Is that true?
So many children, there are women and children, and many of these people you see, and there are much more than these pictures you see, many of them were not even protesters, they were just bystanders. Some of them were in their home or watching from the balconies or windows. They were shot dead by security forces.
Gosh, and in the previous, if we go back to the previous slide, I noticed that the police are wearing uniforms in Iran which say police in English. What's that about?
Well, they are very well equipped with all the gear and equipment they can get, and they import all of that from European countries, from Germany. And this is nothing compared to much more sophisticated equipment that they have. This is they have no problem in using and importing all of those equipment coming from European countries particularly. And this is an interesting point for those who will be interested in business and human rights, for example, which is one of the topics you can study when you study a law degree at Kent. Okay, I'm going to hand over to you, Sian, to take us through challenges to the right to protest and liberties in the UK.
Thank you. So the first thing that we're going to look at is, as Mohammad alluded to, the Police Crime Sentencing and Courts Act, sometimes referred to as the Policing Act. As one of the participants actually mentioned it as one of the, identified one of the protests as one of the protests against this when it was a bill. So it passed through all stages of Parliament and has now become law. And as of 2 days ago, it is now beginning to come into force. Now, there are several things of concern to human rights lawyers, but if you were studying, let's say, human rights and English law, we would be going through quite a bit of this. So, for example, police chiefs will be able to impose conditions on static protests, such as those organized by Extinction Rebellion, where roads and bridges are occupied. And they'll also be able to fix start and finish lines, and the rules will apply to protests by just a single person. But the one of the perhaps more concerning things for us, because of what we've been looking at earlier on today, is that it gives police chiefs the power to set noise limits. Remember, peaceful assembly under Article 11, the word peaceful refers to a lack of violence rather than a lack of noise. So if we consider for a minute a single person holding a placard, sharing their views on that placard, it might be, I don't know, something along the lines of decarbonize Britain or something like that. And they might have a loud hailer. If they refuse to follow police orders, police directions, they may be charged with a criminal offence and may be liable to a fine of up to £2,500. Someone's asking, how would the proposed public order bill on protests interfering with national infrastructure take these limits on protests further? Very important question. It will take those limitations further. The limitations that were sought, the further limitations that were sought by the government were thrown out by the House of Lords at a very late stage. And so the Public Order Act, it will bring those limitations back into play, and it will go through Parliament and no doubt go through successfully. As Mohammed says, we have a Parliament where the party in government has a very large majority, and so has the ability to push through legislation, even though it might be unpopular to the population at large. So now the other thing that is of concern is that it is also now a crime to fail to follow restrictions that the protesters ought to have known. So in other words, protesters will now be deemed to somehow have acquired knowledge about what limitations should be on their right to protest, even if they've not had a direct order from a police officer. Now, previously, police have needed to prove that protesters knew that they had been told to move on before they can be said to have broken the law. And the new law also includes an offence of intentionally or recklessly causing public nuisance. And this is designed to stop people from occupying public spaces, hanging off bridges, or employing other similar types of tactics. Now, you may think, oh, well, that's, that's fair enough. But let's think about the noise aspect, because I think this seems to be a bit worrying. Consider this. Conditions can be imposed on marches and static protests where the noise generated may, and I quote, result in the intimidation or harassment or cause serious unease, alarm, or distress to bystanders. Any bystander could say they feel considerable unease. They might say, I need to get to work. This is causing me trouble. I can't get to work because there are these noisy protesters. Or result in serious disruption to the activities of an organization which are carried out in the vicinity. What is serious disruption? Or have a relevant impact, what's that, on persons in the vicinity, and the impact may be significant. Furthermore, the Act allows the Home Secretary, in other words, a cabinet minister, a very powerful cabinet minister, to define serious disruption. The question that we need to ask is it a good thing to have a politician deciding what amounts to serious disruption, or should this be a matter for the courts? Imagine that you're protesting outside the South African embassy at the height of apartheid. For those who don't know apartheid, this was about separating white people from people who weren't white, and the white people got all the advantages and people who weren't white got all the disadvantages and were vastly discriminated against. They lived separate lives in separate townships. It is apartheid meaning separate or separateness. If the South African embassy in the 1980s had this legislation to rely on, they'd be able to say this is causing serious disruption. Is this a good thing? Does this unduly suppress the right to protest, or is it a good thing? Now, if we can move to the next slide, Mohammed. What is interesting for us as critical lawyers, as critical scholars, is to look at the background to this legislation. And there's a joint committee in the Houses of Parliament that represents, that constitutes both elected members and members from the House of Lords. And they are drawn from all the political parties. So there are 12 members from the House of Commons and House of Lords, with members from the Conservatives, Labour, Lib Dem, Scottish National Party, and there's a crossbencher in the House of Lords. And they examined the question of the proposal, as it then was in the bill, of restrictions on noise in protests. And they said this, remember, this is a cross-party report in June last year. A restriction on the right to protest that targets noise is of particular concern, as it strikes at the very heart of why people gather together to protest. To have their voices heard about an issue that is of importance to them and which they want others to treat with importance. Then we have to go on and note something else they said, which I think is a very significant point. We also note that the larger and more well-supported a demonstration, the louder it is likely to be. Restrictions on noise could disproportionately impact the demonstrations that have the greatest public backing. Think about that for a moment. The more popular the subject of a protest, the more likely it is to be noisy, the more likely it is to be clamped down on. If we could go to the next one. There's a question. Would it not be better if there is wider consensus on the definition instead of leaving it into the hands of powerful individuals, as the politicians would be more likely to suppress protests that potentially cause political harm to them or those in power? Very good point. Marvelously made. These are extremely worrying signs of a government that doesn't like noisy protests. For, you know, I'll leave you to decide why they don't like noisy protests. So the idea of serious disruption tells us that the Act confers unacceptably wide and vague powers to curb demonstrations on the police and Home Secretary, including if they decide that the protest causes serious disruption to the community or activities of that organisation. Now, let's now look at another concern to us as human rights lawyers and as critical legal scholars generally, and that is the scrapping of the Human Rights Act. And this is very recent and very current. So the Conservative Party has been saying for a number of years now in every single one of its party political manifestos, election manifestos, going back as far as 2010, that they want to do various things with the Human Rights Act. Sometimes they say they want to get rid of it, and sometimes they say they want to change it. But the most recent one is the most relevant to us because that's the political platform on which they came to power. And they said this, someone says, attempts to remove the Human Rights Act since Brown's government demonstrates political point scoring instead of sufficient care for human rights. Yeah, I think you're right. The Conservative Party's manifesto in 2019 stated, we will update the Human Rights Act to ensure that there is a proper balance between the rights of individuals, our vital national security and effective government. Someone else says, wider question on the scrapping the Human Rights Act. What would the repeal of the Human Rights Act mean for bringing cases of human rights infringements to UK courts? And what would happen to the Supreme Court's power to issue declarations of incompatibility? These are very good questions. I think the answer to that is it's a bit complicated. It's probably a bit too complicated for us to go into in this webinar. But these are excellent questions and very pertinent. If we go to the next slide, I think it's really important. So the Conservative Party, when it went into the election, said we will. What was the word they used? Sorry, if we go back. Update. Say yes, we will update it. So then the Conservative government commissioned a judge, and by commissioning a judge, you're commissioning somebody who's independent, we hope. We anticipate that a judge is independent of government. And Sir Peter Goss was asked to consider three things. So remember, this is the government asking a judge for its opinion on the Human Rights Act. And it asked him to consider the relationship between the domestic courts and the European Court of Human Rights, number one. Number two, the impact of the Human Rights Act on the relationship between the judiciary, executive, and parliament. That's the three branches of government. And three, whether there is a case for changing the way in which the Human Rights Act applies outside the UK. And this, Sir Peter Goss, it was referred to as the Independent Human Rights Act Review. Right, okay. Now, the findings were submitted to the government in autumn 2021, the findings of this review, and they were published in December 2021. And based on the majority of the representations made to that judge, the conclusion was in favor of keeping the Human Rights Act with only minor changes. In addition, the Joint Committee on Human Rights also launched its own inquiry into, at the time that judge was commissioned, and it also came to the conclusion there should be no changes to the Human Rights Act. No, there was no case for change. So I think I'm now going to pass back to Mohammad. He is going to tell you what happened.
Well, the opposite of that happened. Here is the bill, the Bill of Rights Bill. Ridiculous name, but that's how it is named, the Bill of Rights Bill. This bill, it was introduced to Parliament just last week on 22nd of June, and it will repeal the Human Rights Act and replace it with a Bill of Rights. The government could simply have amended it, but instead they have decided to repeal and replace it, which is beyond the manifesto. The government has made it clear that the UK will remain a state party to the European Convention on Human Rights, but the bill also give effect to the same set of conventions as in the Human Rights Act. But that is just the surface. The bill is a major constitutional change, and it will change a lot of things. I only mention a couple of them very quickly here. The domestic courts in the UK are currently required to interpret domestic legislation compatibly with the Convention rights. This has enabled the UK courts to confer a high degree of protection to human rights through methods of interpretation. The bill will restrict the court's power to do that. The human rights also currently requires UK courts to take account of decisions of the European Court of Human Rights. In the bill, this is removed. So, and overall, the bill will restrict people's ability to challenge public authorities as they used to be able to do under the Human Rights Act. Importantly, in attempting to pass this legislation, the government is undermining, sidelining Parliament. They have refused to allow Parliament to carry out pre-legislative scrutiny of the bill, which is important and occurs when a parliamentary select committee gives a detailed examination of the draft of the bill before it was drawn up by government. It didn't happen. And this is from Twitter. Someone has had fun with a statement by the Justice Secretary, Dominic Raab. So the idea is, contrary to his assertion, the bill does not enhance or strengthen human rights protection. It weakens it. The bill also significantly diminishes domestic protection of human rights and turns the clock back for our rights and liberties. So I stop here and I hand over to Sian to tell us about the distinctive critical approach to teaching learning law on these issues at Kent Law School.
Thank you, Mohammad. We've tried to do various things in this webinar, but one of the things we're going to do now, we're sort of drawing it to a close, is to to kind of comment on our critical approach. We are, I think, internationally well known for our critical legal approach to legal education, where we teach not just what the law is, but also looking at what the legal underpinnings or the socio-political underpinnings, the non-legal underpinnings for the law, and its wider historical context, the socio-political context and implication for society and people's lives, obviously in this jurisdiction. We have tried to give you a taster then of the way that we teach by giving you this short webinar on the right to protest. So as you've seen, we teach not only what the law is, but why the law is and how the law came to be, sometimes despite the opinions, the very strong opinions of people in a position to be able to assess the need for more law or the need for a change in law. So we examine socio-political context, we ask our students to ask questions about the potential future shape of the law as well, based on current trends. So in our webinar, we've looked at the importance of the right to protest, its legal and human rights underpinnings, and we noticed several ways in which that right has been restricted by a series of by recent legislation and by one proposed new piece of legislation. Legislation is law passed by Parliament. We attempted to shed light on what happens to protesters in the context of autocratic regimes like Iran or Rwanda, or where were the other ones?
Sri Lanka.
Sorry?
Sri Lanka.
Sri Lanka and Hong Kong, and others have mentioned them in the chat. So in these autocratic regimes, it's well known that democratic processes are either less strong than they are in the UK or they're absent altogether. And this served to illustrate that without strong legal protections established in a state governed by the rule of law, people young and old can risk their lives in order to get their voices heard via a protest. Of course, we don't live in the UK, fortunately, in a state governed by an autocratic government. That's not the point I'm trying to make. However, we have seen some worrying signs about the state of the right to protest in the law in this country and the potential future shape of the law in this country by means of the new Human Rights Bill, or the new Bill of Rights bill, recently laid before Parliament. This bill, mark our words carefully, will have an impact on all rights in the UK, including the right to protest. And we need to care about that. We need to care about that as citizens or interested members of the polity. And we need to care about it most importantly as legal scholars, because that's our job. Our job is to look at the law and to examine it and to subject it to critique and to suggest improvements. We need to care about what happens to our rights, and we need to develop informed opinions about law and our rights based on evidence. And that's what I hope we've been able to demonstrate. Back over to Mohammad.
Thanks very much. I would say there are 3 take-home points from this webinar. The first thing we learned today is what the right to protest is. We learned about the rights to freedom of expression, freedom of assembly, and that they are interrelated and mutually reinforcing as manifested in the right to protest. These rights are part of the foundation of a democratic society. And it is important that you know your rights and inform yourself about what is happening to them. Legal changes are happening very quickly. As we talked about, some of these new developments are happening very quickly. And on one level, if you don't know the new law, you may fall foul of them. But as we saw, human rights are under attack. The clock is being turned back for liberties. So it's even more fundamentally important to understand why our human rights, including our right to protest, matter. Once you lose a right, it is more difficult and unlikely that you will ever get it back. In other words, the way towards authoritarianism is a slippery slope. So we should be aware and alarmed when our rights to dissent and to speak out is being taken away. And it should be clear to us what it means for our liberties and the impact this will have on our society. The right to protest is, the second point I would make is that the right to protest is systematically denied in many parts of the world. Thankfully, it's not the same in the UK, as Sean said, but there are also worrying developments. What are we seeing is that the government has been working to dismantle the tools of accountability and protection for fundamental rights and liberties, for example, by the Policing Act and scrapping the Human Rights Act. The government is also shutting avenues of accountability in Parliament, through the courts, and as we discussed in this webinar, on the streets. These are crucial tools to stand up to power, and they need defending. And the final point, I would say that we need to have a hard look at the legal and democratic processes that over decades brought us, I should say, completely legitimately to the place we are now. All these laws, such as the Policing Act, have made their way through Parliament against a backdrop and despite widespread criticism, including from Parliament's own Joint Human Rights Committee, as Sean told us, and from also criticism from human rights organizations, from activists, yet they became law. It is therefore important to develop a critical perspective and see how law is being created and how it is affecting our lives. Back to you, Sean.
Thank you, Mohammad. We've just had someone say the new bill will have impacts where cases like the Belmarsh case will no longer have backup from the Strasbourg court, and that will be concerning, as you explained. I mean, these are complicated legal arguments, which I think are outside the scope of today's session, but these are very, very valid points. And if you were to come and join us at Kent Law School, we'll examine questions like these and many more in any of the seminars that relate to human rights or constitutional law. So what to read if you want to learn more? So our colleague Katie, whom you can't see, has put in the chat a whole bunch of things that you could be reading, and I think also it's on a slide there, so I think you'll be sent the slides, and the whole thing will be available on YouTube fairly shortly. But if you want to learn more, there are some useful online resources that you can access very easily. You'll be able to see the text of the Police Crime Sentencing and Courts Act. You also will be able to see the Bill of Rights bill, and then there's some guidance and analysis by human rights organizations and lawyers and academics and so on. So, excuse me, there's a whole load of resources there. You can always ask us for more information if you'd like. Just to let you know that there's another Summer of Law webinar, which will be held on the 14th of July on ethics in the law. So if you're interested in that kind of aspect of law, please do come and listen to our colleagues, Dr. Marie Kerin and Lucinda Griffiths. And if you want any more information in relation to that, just see the Summer of Law webpage. And you can find out more about KLS, I think, on the last slide. There, I think. And you can join us on social media platforms.